President Joe Biden is pushing for immediate action on the Respect for Marriage Act. Monday, the commander-in-chief tweeted that I urge Congress to quickly send this bill to my desk, where I will promptly sign it into law. The full Senate is expected to vote on the legislation after the Thanksgiving holiday. Cleared a procedural vote last week with the support of 12 Republican senators. The House passed its version of the bill over the summer. Now, if it becomes law, the legislation would federally recognize same-sex marriage and provide legal protection for interracial marriages. Joining us now to get into the details of the bill and what it would mean if the Supreme Court overturned Obergefell v. Hodges is Dean of Berkeley Law Erwin Chemerinsky. Welcome, Dean.
Good morning. Good to talk with you.
Yeah, thanks for joining us. So this did clear the procedural vote in the Senate with significant Republican support. I believe 12 Republicans voting for it. So should indeed is expected to pass and then be signed. What will this law accomplish in the event of some, I think, unlikely, but people are concerned about it because of what Justice Thomas said in his recent opinion? What is being protected here?
I think it would do three things. First, it would explicitly repeal the Defense of Marriage Act, a law adopted during the Clinton administration. Second, it would say, for purposes of all federal laws and benefits, marriage includes that between same-sex couples. And third, it would say that states have to recognize marriages that are same-sex or interracial from other states.
It's curious. I think some people are asking questions about why it is that abortion rights, Roe hadn't been codified or Casey hadn't been codified over the last 50 years. They're asking questions about why it is now only that Democrats are acting on these things after having kind of dangled the concerns about Republican interfering with some of these rights to win elections over time. Are there any actual structural, strategic, barriers to Democrats having codified not just this, but other kinds of rights protections before this time?
Congress could have passed this law at any time. Congress could pass a national law to protect abortion rights or a national law to outlaw abortion. I think the answer to your question is simply politics. At this moment in time, same-sex marriage isn't the divisive issue that it used to be, but abortion remains that kind of a divisive issue.
I think some of the opposition to codifying gay marriage vis-a-vis this bill on the right is some of it is actually not strictly, or they're saying it's not strictly objection to gay marriage, but concern about religious freedom or concern about tax-exempt status for churches, for businesses getting in trouble for not recognizing same-sex marriages, maybe anti-gay discrimination, all that kind of. That's what I'm hearing from conservatives, at least. What do you make of those issues with the bill?
This would have nothing to do with tax status for any churches. In terms of businesses, already the Supreme Court has interpreted federal employment discrimination law to prohibit discrimination against gay, lesbian, and transgender individuals. This wouldn't change that at all. This simply would say, for purposes of federal law and federal benefits, same-sex couples that are married are treated the same way as opposite-sex couples. And it would say that every state has to recognize a same-sex marriage from another state. It goes no further than that.
Yeah, so to that point, an Associated Press fact check looked into claims that the Respect for Marriage Act would allow the IRS to revoke the tax-exempt status of churches and that only support marriages between a man and a woman. And according to their reporting, quote, nothing in the legislation would allow churches to be denied tax-exempt status or other organizations to be sued for their stance on marriage. Dean, why are we seeing confusion here despite what seems to be clear-cut?
There still, in some circles, is opposition to same-sex marriage. So those who oppose same-sex marriage don't want to see this bill passed. But they are making an inaccurate claim. As the AP fact check found, as I said a moment ago, nothing in this bill would in any way revoke anyone's tax-exempt status. Nothing would take away anyone's religious freedom. It would simply say that federal law recognizes same-sex marriages the same way it recognizes opposite-sex marriages.
Well, let me ask you this. I mean, some conservatives have said post-Dobbs that the kind of liberal concern about what it potentially could mean for same-sex marriage or interracial marriage was overblown, and that Thomas's language was being kind of exaggerated by liberals to create the perception of a threat and basically make gin up support for Democrats during election seasons. What do you make of the parsing of that language? Does it indicate to you that the court is really coming for some of these other privacy rights and not intending to stop at abortion?
Let's start with Justice Thomas' language. It wasn't exaggerated at all. Justice Thomas said, now that we've overruled Roe v. Wade, we should overrule Griswold versus Connecticut, the 1965 decision that said the right to purchase and use contraceptives, Lawrence versus Texas, the 2003 decision that said that states cannot prohibit private, consensual, adult, same-sex sexual activity, and Obergefell versus Hodges, the 2015 case that said that there's a constitutional right to same-sex marriage. In fact, Justice Alito's majority opinion in Dobbs said that the only rights that should be protected in the Constitution are those that are stated in the text, part of the original meaning, where there's a long, unbroken historical tradition. Marriage equality wouldn't fit into those categories. That's why I think Congress wants to pass this bill now.
So I'm trying to find an example, something that conservatives are worried about from a religious freedom standpoint. The Daily Signal, which is a publication produced by the Heritage Foundation or in partnership with the Heritage Foundation, interviewed a Catholic director of a Catholic college who said, well, what if our college refuses to allow a same-sex married couple to live in, for instance, graduate student housing for family, and would be worried that they'd be subject to new litigation under this exact law?
This bill would not be a basis for such litigation. There might be other laws that provide a basis for litigation. Remember, what this bill does say, for all of the federal laws, and there's hundreds, maybe thousands, that give a benefit to married couples, but not to unmarried individuals, same-sex married couples get those benefits as well. And it says that if one state recognizes a marriage as valid, other states have to recognize that same-sex marriage as well. But it doesn't provide any basis for suing the college with regard to who it does or doesn't rent space to. I have to emphasize, though, there are other laws that might provide a basis for such a suit.
I guess it's a little difficult to understand why that wouldn't be a legal hook for someone who is in a same-sex marriage at a let's say religious institution, a Catholic college. Why wouldn't they be able to sue on the basis of this federal law that they're being discriminated against? And isn't it the case that not having federal protection, not being a member of a class that is federally recognized in the past, has prevented people from bringing exactly these kinds of suits because they don't fit into any one of the neat equal protection categories?
It's important to draw a distinction between a federal law that governs how the federal government operates versus a federal law that regulates private entities.
I see.
This bill would say that the federal government, when it decides whether somebody's a married couple for purpose of income tax, has to treat a same-sex couple the same way. There are many federal laws that regulate private behavior, such as laws that prohibit employment discrimination by private employers. This bill isn't of that sort.
And the fact that the college potentially taking federal dollars for funding wouldn't have any implications?
By itself, this bill would not, but there's another law that already would, because this bill doesn't regulate private colleges, but Title IX of the Civil Rights Act says that educational institutions that receive federal funds can't discriminate on the basis of sex. And the Supreme Court has said that a prohibition of sex discrimination includes a prohibition of discrimination based on sexual orientation or gender identity. Title IX might already prevent that college from discriminating, but this bill is about how the federal government itself operates.
I mean, the vast expansion of the interpretation of Title IX, which originally had to do with making sure women had access to the same sports teams or clubs, et cetera, into sexual activity, into due process, into free speech concerns. I mean, the way that has happened over the years is probably what some conservatives who object to this bill exactly have in mind, worrying that down the line this will be a gay cake baking situation. But
I disagree with your premise, if I may. I don't think that Title IX was ever meant just about equalizing funding for girls and women's sports, though that was an important effect of the law. Title IX is much broader than that. It says educational institutions that receive federal funds can't discriminate based on sex. And I think it was always meant to include athletics, but always meant to be about much more than that.
I mean, well, okay, we have to go. I disagree, but we'd love to have you back to discuss that more at a future date. Thank you so much for joining us, Erwin Chemerinsky.
Thank you.
Thank you so much for joining us this week. We hope you have a wonderful Thanksgiving. Take care, everybody.